excellent day, filled with good comments. Craig made the comment that we have a panel on both sides of the podium. We have a panel out here and a panel here. So we hope that this will be a continuation of that trend, and that a lot of the things that we talk about up here will actually end up in a conversation. And that's the way we'd like to see it happen. We do have, I'm Gary Crane. I'm currently serving as Morgan City Attorney. When you get so old, you're replaced. I used to be Layton City Attorney, and this is my replacement. They tried to get somebody who looked exactly like me, as close as possible, and so they chose Clint Drake. But I'm happy to have Clint with us. Clint is the past Bountiful City Attorney. He's also served in Syracuse, Roy, as their city attorneys. And actually, I'm proud to say that he started in my office many, many years ago. And too long for me to like to remember. But glad to have Clint here with us, representing the government side and some of the things that he actually sits on the Eminent Domain Advisory Board, which is the board that actually governs the Ombudsman's office. And this year they're looking at alternative dispute resolution, putting into play some of the things that they've talked about over the years, maybe making some of that dispute resolution, those possibilities, a little bit more plain in the statute. And so we're looking forward to hearing what those plans might be. I think those things have been discussed in the Land Use Task Force, which is the task force of both private development and municipalities and counties. I think those have been discussed, and we'd like to hear your comments and your feedback on some of the responses. And then we've also got Paxton Guyman, who is also, in my opinion, one of the best land use attorneys in the state, if not. Sorry, Brent Bateman at the back of the room. Yeah, okay. But Paxton I've known for years as well. He's currently the attorney for Edge Homes. Also does a little work with York and Howell, is that correct? And has his entire career, I think, has dealt with land use issues. And so he will provide us with a perspective from the private sector side of things. And I'll try and keep the two apart. That's my job. And so keep them, at least the conversation moving forward. Just by way of explanation, online, Craig has placed, he has a handout, which is an excellent handout. This session is not intended to outline how an appeal authority works. These guys, in presenting to you, may present some ideas on tips and tricks on what to do when it comes to appeals. But our job today is to kind of give you a perspective on some things that might be coming up at the legislature, and to ask you questions about what might possibly be. We've got a good contingency of elected officials and private individuals here. What is the best way to resolve disputes? Is it better to do it at a state level? Is it better to do it at a local level? It's interesting because in anticipation of this, and I could probably have done an entire session on all the different ways that the states have managed controversy in the land use arena, but I don't find very many cases across the country where there is a land use court specifically assigned to land use, nor do I find very many cases where there is a land use dispute resolution on a statewide level. It seems that most of the states, except for those with environmental issues, or those, every state with housing issues, those seem to be the two things that the states have actually taken control of or brought back and created appeal authorities to be able to address. There are many questions surrounding both of these options, the alternative dispute resolution option, as well as whether or not there ought to be a statewide appeal authority. And so our intent is to discuss the broader issue today. The actual materials on how, tips and tricks, I guess, from Craig Call on how appeal authorities work is in your materials. It will be in your materials, and you can actually look at it online. In addition to that, you need to know that the ULUI is very, very willing to come out to any jurisdiction and talk to you about appeal authorities. I am not ignorant of the fact that many of us still have, as cities, boards of adjustment. In 1926, when the first Standard Zoning Enabling Act came into being, and then shortly after that, when the first case challenging it came into being, they tried to figure out a way of softening what they were doing by having government essentially affect private property rights. That's when zoning came into play. That's when it began, and they actually developed over time a Board of Adjustment. Board of Adjustments were never professionals, almost never professionals. Some jurisdictions do require that they be professional, but to a large extent, boards of adjustment are individuals that the mayor thought would sit, and in many jurisdictions, the only ones that would sit on a panel of 4 or 5 individuals, whatever it happened to be, and listen to zoning appeals. They were often referred to as a pressure switch that you could actually, a release valve, in case the zoning ordinance got to be too onerous, is what it was. So since that time, we've tried to develop additional means of dealing with zoning disputes. And I thought probably the best way of beginning the presentation is to let Paxton from the private sector give us a real life example of one of those situations where some type of resolution is required. And during that, raise a number of the issues that the league is dealing with and that the private development community is dealing with in providing for some type of process to be able to resolve these issues. And so with that, I'm going to go ahead and let him give us an example. I hope it's not too severe because I haven't heard it yet, and I hope it's something that we can respond to as cities. But I'm going to go ahead and let him proceed.
Thank you very much, Gary. I appreciate that. It's good to see so many people stayed in this room rather than going to the other one. I'm glad we have some people here for this presentation. I've been practicing land use law for over 20 years. I've been involved in all sorts of land use disputes, some of which have gone all the way through trial and through the appellate system. And we're here because most of us believe that if you get reasonable people together, you can figure out solutions to land use disputes and shouldn't have to go through that litigation process. I'm a firm believer that the litigation process is the worst way to resolve disputes, but sometimes it's the only way. And unfortunately, sometimes it's a necessary evil to get through to a resolution. What I want to share with you today is a real life example that I handled for one of my clients involving what I consider to be a land use dispute. And one of the points of this story that I'm going to share with you is a question for you to consider, and that is there legal recourse for every land use decision or city action that affects development negatively? Is there always recourse? Does it go to a land use appeal authority? Do you go to district court? What do you do? So let me lay out the facts. If you'll bear with me, listen to these facts, and then I want to know how you would handle this situation, what you think the right recourse is. And I want to generate some discussion, and then we'll see where we go with this. So again, this is a true case, and here are the facts. There was a 90-acre parcel that my clients wanted to annex into a city that will go unnamed for development as a residential community. They started the process by filing and paying the application fee for annexation. They met with city staff. They went through the process of figuring out what the process would be, which turned out to be a 2-year process. The city made it clear that they would not annex the property unless the developer acquired sufficient water rights for the proposed use, which the developer then did, that's not uncommon, at a great cost to acquire those water rights. They went through the process, which would, I think, be considered a legislative process, of getting the city to amend its annexation policy plan to update it to include this land. They did a feasibility study. They went through the Planning Commission, the City Council, and there were 2 final steps in the process. The penultimate, or second to final step, was to get an annexation and development agreement negotiated and approved, which they did. And by a vote of 4-1 at the City Council, the annexation agreement was approved. The final step in the process, which had occurred at the next meeting, just a few weeks later, was for the city council to then approve the annexation ordinance. So we're 2 years into the process. We're literally hundreds of thousands of dollars into this with the water rights, the feasibility study, the plans, the detail. And what happens? I think you know where I'm going with this. One of the city council members switched and voted against the annexation ordinance. As a result, there was no annexation. That failed. Now the vote, the annexation ordinance vote, is clearly a legislative decision, correct? What's the recourse? If you're this developer, you've invested 2 years of your life to go through this annexation process. It is a significant project. At each step of the way, the city gave its blessing. We approved the annexation policy plan update to include this property. All the way through it, we approved the annexation agreement, but the city ordinance was very clear. There is no approved final annexation until the annexation ordinance is adopted by the city council. And the city council said no, because one of the members who had previously voted to approve the annexation agreement changed his mind and voted against the annexation ordinance. Now I throw that out to you. What's the recourse in a situation like that? If you look at LUDMA, the Land Use Development Management Act, it defines a land use decision as an administrative decision of a land use authority. It defines a land use regulation as a legislative decision enacted by ordinance. What is this? This is a legislative decision not to enact an ordinance. What's the developer's recourse in a situation like this? I'd love to get some input. And by the way, I'm not going to say there's a right answer here, because I'm not sure there is. Any ideas? I see some smiles. Is there a hand by somebody? David?
Was there a reason given? Were there findings made by the commission in their determination to?
None. When they took that vote on the annexation ordinance, there was no reason articulated whatsoever. It came up for vote, the votes were cast, there was no explanation. I would argue the record was devoid of any explanation for that decision. So what we ended up doing in this case, and again, I want some, was there a hand back there? So yes, they, prior to getting to that point in the decision, the question was it in their annexation policy area? Originally, no, but during that 2-year process leading up to this, the city council amended its annexation policy plan to include this 90-acre parcel. So that's a legislative decision going towards the annexation, correct? A hand there? Okay. The question is, can you call it back for reconsideration? Would you want to do that? Wouldn't that tip your hand and maybe give them a thought, well, maybe we ought to articulate a clear reason and policy-based rationale for why we're going to vote against this ordinance? Maybe we'll get it right the second time. Wilf.
So one of the ways to deal with an unfavorable legislative decision is to put it to a referendum vote. Now, you know, that's often done when, like, say, a city council approves a rezone and the residents don't like it, and
Right.
they'll collect the signatures and get it on for a vote. I mean, that's a possibility, but where you're trying to annex land into a city for development, that may not go so well, but that's a possibility.
Okay, not a bad idea. Hand over here.
Could you amend your application and make it sufficiently different to come back in and ask again? Similar, you get similar stuff, but just kind of amend it to be more concession driven based on what the city's asking for. But again, if they didn't give you any reason for denial, I think that's the first thing you got to ask for. Is say that you've got to have justification.
Right. Good idea. You know, amend the application, come back again, get a second bite at the apple. You know, a lot of cities say you can't refile the same application unless you do like a 1-year waiting period. So that may have applied here as well. Lynn.
Two thoughts. One is if you feel like their decision is deficient, you could try and challenge it in court, but that's not a high likelihood of success on a legislative decision. And then there's a political solution. Find a supportive candidate and run them for city council.
Okay. So, Lynn, brilliant. So let me just tell you what happened. I'm going to finish the story. So we ended up filing a lawsuit, and I've got a copy of it here. The argument was essentially this. It's not really one of estoppel, because it's very hard to win an estoppel argument against the city when you're up against a clear ordinance that requires approval of the annexation ordinance. But it said basically that the council decision denying the annexation was arbitrary and capricious and must be reversed because there was no reasonably debatable basis to justify or support the city council's refusal to approve the annexation ordinance. Well, all that basically was a placeholder to show that we were serious. We wanted to figure out a solution here. We filed the lawsuit. We actually survived a motion to dismiss, interestingly enough. But when we got to looking at the case law, there's really no case law in Utah to win this case on. You can't point to any reported appellate decision to say a city council has to approve an annexation ordinance if they've approved each step of the way leading up to that. So what we did, Lynn, was precisely what you said. The developer found a different candidate who wanted to run for city council, one who was in favor of their annexation. At the next upcoming election, that person won, probably thanks to some of the funding that was provided. And we got a second bite of the apple, and it was approved. So we had to rely upon the political process, because I do truly believe that in this fact pattern, there is not legal recourse, even though I think most people would look at the facts and say, this is just manifestly unfair, right? How can somebody flip-flop without giving any justifiable explanation for changing their vote at that final step in the process? Anyway, that's sort of an extreme example. What I will say is that in my experience, 95% of the time, I can sit down with the city attorney and figure out a fair, reasonable solution, or a county attorney. I look in this room, I see Chris Preston, Kevin Thurman, Lynn Pace, all of whom I've worked with through difficult challenges, and across the board, we have found solutions. It's a matter of sitting down and putting in the time to reason through it and avoid litigation. And I think if you've got smart, experienced people on the other side, that's the best answer, not court systems.
So, an excellent point. The distinction between legislative acts and administrative acts. How much success have we had in the state of Utah of ever having a successful challenge to a legislative act of a city? The answer is none. None. I don't know of any. I think there's one case that came close, but there really isn't. So your recourse isn't even good with the courts when you're looking at a legislative act, which is a land use regulation. Way back in time, I remember discussing whether or not we ought to call them administrative acts and legislative acts. And we ended up in deciding on calling them land use decisions and land use regulations. But land use regulations, really, there is no recourse. Exactly what you said. A political resource, yes. A referendum recourse, yes, but not a legal recourse, not a recourse through the ombudsman's office, although they may render an opinion that that's just really not fair. It doesn't sound fair. And so most of what you get in the state of Utah, the appealable cases, are administrative cases. Example of an administrative case is we had just recently there was an individual who had and he's not here, so I can go ahead and tell this, and I'm not going to name the city, but just a simple thing. The individual there were 10 townhouses. The individual owned one townhouse at the very end, number 10. Number 4 burned down. Number 4 had to be reconstructed. It did affect, with smoke damage, the other units in place. One contractor was asked to do the reconstruction on the entire thing. He went to the city and he went to get a building permit for the center unit. He got a building permit for the center unit, but the city according to the contractor, refused to, even once the other units had received certificates of occupancy, in other words, they're just minimum smoke damage, the city refused to issue certificates of occupancy for any of the other units until the center unit was built. So the owner of the property ended up in waiting 47 weeks for the center unit to almost be built. And the answer is there's a land use question, right? And that is, should a certificate of occupancy, it's a building code issue, but should a certificate of occupancy have been issued for the other units, or should it have cost this guy 47 weeks worth of revenue to wait for that center unit to receive its certificate of occupancy? And so where would you go? Where do you go with a question like that? Number 10 had no idea, and that's part of the problem, is that individuals with legitimate land use administrative decision issues really don't know where to go. If you go to Paxton, he could tell you. If you go to Clint, he could tell you. But what ended up happening is just contact between an attorney and the city that happened to actually be involved in it, and the permit was issued immediately, which tells you, there's a disconnect there. And the question that every single year up at the legislature we try to resolve is, how do we resolve those issues, those administrative issues? The Paxton issue is a big issue that isn't going to be resolved through anything that we set up on a statewide level. I really don't believe it is. It's resolved through collaboration and through education a lot of times, and maybe even a better annexation agreement that that ties the city down a little tighter, if the city's willing to be tied down a little tighter. In other words, making the city do what they ante up to the line if you've committed to do something and they're willing to stick their neck on the line too. What I'm going to do, let me just turn a minute over to Clint Drake, who sits on the Eminent Domain Advisory Board. And the question I just, or the illustration I just gave on the condominiums could be resolved through an alternative dispute resolution process. And after doing a lot of research, not a lot of research, but a lot of skimming research across the country, it seems to me that a lot of the disputes that are being resolved more at a local level, or by a board of adjustment type group, or by an administrative hearing officer. More and more in the state of Utah, we're turning to the administrative hearing officer, which is an educated individual in land use issues that knows and understands land use, and people are beginning to understand that they have that right, and they're able to do that. But this year at the legislature, we're looking at the possibility of making some changes in the ombudsman's office that will directly affect that. Let me have him just briefly go through and just illustrate some things that this property owner could have done.
Thanks, Gary. So Paxton mentioned that 95% of the time he can sit down with the city attorney and get it resolved, and that's certainly been my experience as well. And I think that collaboration and discussion and communication, particularly at the local level, is very important in getting things resolved. But there is that other 5%, and what do you do when you're in that 5% category? So this is the interactive portion of the meeting. I just want to raise the hands. I don't need any answers, but just out of curiosity, how many in this room have participated in some form, in some sort of a process with the Utah Property Rights Ombudsman in that office? And I'm just, again, out of curiosity, of those hands, how many was through mediation? How many have utilized mediation? How many have utilized the advisory opinion process? And then I'm going to call this phone calls or emails, what their office calls an informal contact. How many just phone call or email? So that's just about everybody in the room, and I saw hands on several hands that were probably all of those processes. So I definitely want to talk about those. But I also want to talk about something that a lot in this room may not know about, and that's the advisory panel. How many in this room have participated in an advisory panel through the Ombudsman Office? So we've got a few hands that have been raised, but much less. How many in this room didn't know about the advisory panel process and are saying, what are you talking about? Okay, so that's one of the reasons that I'm here, is to help explain that. Let's just get right into that. So advisory panel process is basically an opportunity to go maybe one step beyond the private developer, private property owner meeting with the city attorney and get some independent, for lack of a better term, independent skin in the game to maybe do a quick check of what's going on. So this is kind of in its pilot program. I reached out to the Ombudsman Office last week and had a good discussion with them and asked them how it's going. They told me that I was good to talk about this and that they're trying to roll this out and make this a much more useful tool. The legislative changes that have been discussed through the board and through the Land Use Task Force are largely attempts to make the process more efficient. This is one of those things. This isn't a legislative change. This is something that's already in the process. So what the advisory panel is well, let me give you a little background first. There's been about 10 or so that have been requested from the Ombudsman Office at this point. They've completed 3. My understanding is the whole process from the request to the resolution is supposed to take about a week. And I think that that's what's been happening so far. What it is you reach out to the Ombudsman Office and you say, I'd like to participate in an advisory panel. And if both parties are amenable, you schedule an advisory panel. What that advisory panel is 2 representatives. I think they're probably attorneys, or usually attorneys, 2 representatives that are taken from 2 lists. One list is a list that is provided by developers, private property owners, and the private sector. The other list is taken from city and county attorneys, the government attorneys. They take an attorney from each of those lists, and that comprises the advisory panel. They then request basically an agreed upon statement of facts. This is a great thing because it requires the parties to kind of reach out and communicate with each other and agree upon the facts. So they get the stipulated facts. Those stipulated facts are provided to the 2 advisory panel members. They review that, and then they have a meeting. It can be virtual or it can be in person. In that meeting, they discuss the facts, and the parties are able to either meet together or have breakout sessions similar to a mediation, and they talk about the facts, they talk about the issues, they talk about the law. And then once that's complete, the panel, the 2 attorneys, go back and have a conversation between themselves. The ombudsman attorneys are not involved in that process because they want to remain independent in case there is a need for a mediation or a advisory opinion process later on. So they remain independent from that process. They participate in the discussions that are happening with the parties, but not with any type of a deliberation that happens. When they're done, the 2 attorneys come out and they say, this is what we think, and they basically give them what the Ombudsman Office has described as a gut check, where they say, okay, developer, or okay, city, we think you're wrong, and here's why. It's not a written decision. It's not something that takes additional time. They sit down, they have the discussion, they come out of the private meeting that they have, and they give you their thoughts. There's been 3 that have been completed, and it's had mixed results. I've been told that, I can't remember what the third one was, but one, the advisory panel found in favor of the city. Another one, the advisory panel found in favor of the private property owner or developer, and I can't remember what the third one was. I apologize. But so that's one of the things that's being used, and the Ombudsman Office is requesting that you participate in that process. For me personally, I think it's a great process. I've not participated in it, but it just builds on that discussion that Paxton just talked about, where if we can just sit down in an office and have a conversation, people that are that know the law or educated on the facts, we can generally come to a conclusion. I think those additional 5%, I think there's a good chance that we can also have those issues resolved as well through the advisory panel. So that would be the first thing that I would say about the advisory panel. It still leaves open the option to mediate. It still leaves open the option for a formal advisory opinion and whatever legal remedies that you might have available. And I can't remember if you wanted me to speak to anything more than that. Yeah.
So I really like this idea because I think it's good to get input from outside parties on the dispute and see if sort of reasonable minds can come to a good conclusion. I have been a fan of requesting advisory opinions over the years in certain circumstances because I think that when the Ombudsman's office goes to the effort of getting the position papers from both sides, analyzing it and issuing an advisory opinion, often it does one of two things. It either educates the parties as to what the law really is and how the issue should be decided, or two, it gives the city cover to take the action that should have been taken initially, but there was enough political, I guess, dispute or public opposition that it was hard for the city to make that tough decision, even though it might have been the right one. But when the Ombudsman's office comes in and issues an advisory opinion, I think it gives cover to the staff, to the city council, to the planning commission, whoever's involved, to say, you know what, we see it differently now, and because of the Ombudsman's authority and position, we're going to follow this. Sometimes that's what it takes. The problem that I've had recently is, and I'm sure it's because the Ombudsman's office is getting more and more requests for advisory opinions than ever before. The problem I've had recently is that it's taking so long to get a written advisory opinion. All right, I'm 2.5 months into one that probably is going to be another 2.5 months before it's issued. That's a long time, and sometimes you just don't have the luxury of waiting for a lot of these issues. Marcy, can I just ask you, are you getting more requests for advisory opinions than you used to? What would you say is the reasoning for some of the backlog and the delay?
So I'm Marcy Jones. I'm one of the attorneys in the Office of the Property Rights Ombudsman. Rick Plen is the other attorney, and then Jordan Cullimore, who's out of town, is our lead attorney. So there's just 3 attorneys. Right now we have a backlog. There's 13 opinions in the queue, so it's just a matter of working through those. And we're one of the fastest growing states with a thriving economy, a thriving business model where business is thriving here. People are moving here. You guys are building homes like crazy. We've had 3 attorneys for the last almost 20 years. When we started, Craig was a one-man show, and then Brent took over with 2. We're just absolutely slammed, and we're even more slammed, I would say, as a lot of the growth goes to these smaller communities because they don't have in-house counsel. They don't have folks that really, they need more guidance, they need more hand-holding, they need more being told, you can't do this. So hopefully it's because it's effective, but we're just slammed. So I really like the advisory panel process. It can be fast. I'd say usually it takes 2 weeks to find a gap in everyone's schedule, and right now at least the volunteers on both those lists, or the attorneys on both the lists are volunteering their time, which is, I mean, just huge. We learn something, the community learns something. It's really rapid feedback, which I think is great. Folks have pushed back, though, that it's not in writing and it doesn't have the teeth the advisory opinions have. Sometimes it doesn't give them, particularly cities, the cover they need to go back to their council or go back and say, look, we just can't. But I think it's a great option. I'm going to hand it to Rick in case he has other things to say.
Yeah, I think the last time I looked, as far as total advisory opinion requests that we're currently handling, I think we have a little over 40. And so that's about 13 cases per attorney that we're handling. And then I think people tend to forget also that advisory opinions are half, or not even half, or a third of essentially what our office does. The other half is mediating eminent domain disputes, right? And so we have those cases to handle, and we have other duties, like, I mean, I'll be speaking later today, right? And so we do speaking engagements, we do other things. And so even if we were to dedicate all of our time to advisory opinions, I think we would have full-time work, essentially.
So just another comment on that. This isn't, like I said, there's been some legislative changes that have been talked about with the Land Use and Eminent Domain Advisory Board, as well as the Land Use Task Force. But there's some other changes that have been suggested that are being looked at too, to just help educate the public and for private property owners or cities to understand what they're getting into. One of those would be some sort of a website list that basically shows the queue. It may not show the details of what they are, but just so anybody, a private citizen, a developer, a builder, an attorney, they can go on, they can look it up, and they can see how many advisory opinions are in the queue and where they're at in the process of that, whether it's in progress, complete, so on and so forth, so that as they do that, they can determine whether or not they want to go through that process or maybe try a different solution. And they're not going to toot their own horn, but I'm going to do it for them. I will tell you that I just I had this I interviewed all 3 attorneys from the Office of the Property Rights Ombudsman last week in preparation for this, and I was really interested to find out that in addition to these advisory opinions that they do and the training that they do and the opinions that they do, that they spend an incredible amount of time on the phone. I asked them how many people they talk to, and they told me that the 3 attorneys are fielding about 1,500 informal calls per year. That's a lot of work, and that's coming from city council members, that's coming from private attorneys, that's coming from city attorneys, from planners, from developers, and the vast majority of those phone calls end up with a solution. So I just want to put that plug in that they are doing a lot of good work, and from the city standpoint, particularly with what Marcy talked about with what we'll call the mom and pop type developers or property owners that don't have a lot of knowledge about the law, they are invaluable for cities to be able to say, because when we go and we approach them and we say, we need to run this pipe through your side yard, they don't trust what we say. And it's very nice to be able to say, well, here's a third party attorney that's a free service that you can call, and you can express whatever concerns you have, and they can educate that on that. So I just wanted to put that plug in, that they're doing a lot of good work. And so in addition to those advisory opinions that they're doing, they're constantly on the phone, they're constantly mediating, they're training planning commissions, they're training city staff, they're doing things that are hopefully helping to move things forward and effectively and efficiently.
So we've talked a little bit about some of the issues, the legislative issue that you're talking about, the administrative issue that I was talking about. What are the typical types of cases that need to be looked at and need an answer to your question? Is there an answer for every zoning decisions? I mean, they're the big ones, right? The ones where they're takings issues, for example, or over-exaction, that type of thing. But typically on a day-to-day basis, do we really need a statewide appeal authority in order to deal with those issues? Or is something like this a better way to go?
I've heard discussions about having a statewide appeal authority. I'm not sure who would sit on that board or who would be the decision maker. I've also heard discussions about maybe even having a district court judge who does nothing, a specialist in land use law, who does nothing but handle land use litigation. And candidly, I'm not sure I'm a fan of that. I'm concerned that if you get one district court judge who's called upon to decide all land use cases, what if that judge has a sort of a bias one way or the other? Or, I mean, that's who you're going to be stuck with until that judge retires. I'm not sure I like that because it could lead to even more litigation and appeals. I think the Ombudsman's Office is fantastic. I love that resource. They've done a great job over the years. A statewide appeal authority, I'm just not sure what that looks like and how effective it would be at streamlining this process. My fear is that a statewide land use appeal authority would simply just be one more step in the process before you get to a judge or a final resolution. As far as the kinds of issues, land use decisions that seem to always involve more controversy than others, it seems to me that conditional uses are a real problem. Inevitably, conditional uses involve uses which they're sort of this hybrid, right? They're somewhat permitted, but yet you have to go through a sort of a different process for approval, and you come up with all sorts of conditions to mitigate the impacts of the use. And oftentimes those conditions far exceed, in my opinion, what is necessary to truly mitigate the true impacts of the conditional use, the proposed use. As an example, we were trying to get a conditional use permit for a substance abuse facility in Park City in Summit County. No kidding, we went through 5 full-blown public hearings before we finally got a decision. And these were months apart. The whole process took nearly a year. And I would say, what's the role of the public in a conditional use? It's an administrative process. It's supposed to be administrative. Why is it becoming political by having so much public hearing and allowing so many neighbors to speak against it? My view on conditional uses, get rid of them. Either it's a permitted use or it's not. And if it's going to be a permitted use, it should be an administrative decision. There should be no role for public opposition. It should just be, does the application meet the standards, and if so, approve it. Now, that might be a little bit controversial. I'd be curious to know your thoughts on that. If you think there really is a place for conditional uses. I see Brent Bateman smiling in the back. Thoughts, Brent? Right. And don't you have doesn't the city have the ability to impose conditions anyway for permitted use? If the permitted use is going to create negative impacts, the city always has discretion to impose reasonable mitigation factors, correct? Yeah. Lynn Pace, let's see, it looks like he's got a thought on that one.
Yeah, you could clearly go to simply permitted and not permitted, but that means you'll get a narrower range of permitted uses. The whole concept of a conditional use is it might fit, or we might be able to make it fit depending on the circumstances. And the reason for a public hearing is because the Planning Commission has the responsibility to mitigate any adverse impacts. If we don't take public input to know what those impacts are, how do they know what impacts they need to mitigate?
Fair point. Fair point.
So we used to have a category in the state code called special exceptions. That was even more fun than conditional uses for most jurisdictions. It was completely discretionary, and you could put anything in there as a special exception. However, it did resolve a lot of issues. Around the country, there aren't very many statewide appeal authorities. The statewide appeal authorities are pretty much centered on things like environmental issues. There is a statewide plan for the environment or for environmental issues, and then those appeals where that is being violated go back to the statewide appeal authority. Also, more and more affordable housing or housing is becoming an issue that is going to statewide appeal authority. But some of the issues that are arising are exactly the ones that Paxton raised, and that is, does this now become an additional step in the administrative process so that you have to exhaust that step? Right now, with the ADR resolutions that we've got through the Ombudsman's office, those are not administrative remedies that have to be exhausted. But it would add another step, and just out of curiosity, for the developers in the room, what is the most important thing for you when it comes to developing and dealing with cities? Is it time? I'm hearing it. What is it? It's time. And the uncertainty. Predictability? Yep. That's exactly right. Time is money, right? And so you often do horrendous things, including cartwheels at public hearings and everything you possibly can to get the thing approved. And you're willing to do that. You're willing to spend the money that really would probably many times be excessive exactions, just simply because you can't afford the time to do this. And it almost becomes a balancing for some communities to see how far they, and this is coming from an old city attorney, how far they can push you, and how many things they can get out of you before you say enough is enough. We're going to hire Paxton and we're going to take it up the line. We're going to take it to court. I remember we had one, and really, I think the point I'm making is a lot of this is on the backs of us as cities, on the backs of us to come up with clearer ordinances that give a clear definition of what we expect when somebody comes in for a rezone or for particularly the administrative process involved. We had one situation where the engineer came in and he was very proud of the fact that he had exacted from the developer an entire road, 101-foot right-of-way, all the way through the east part of Layton. And I looked at it and I thought, should I let this go, or should I remind him that there's a thing called excessive exaction, nollen and dollen? And I just kind of hinted at it, and he understood what I was saying. We got back with the developer, and the city ended up buying half of the street and coming up with a better way to do it. But the bottom line is, I think that we as cities have an obligation to try and eliminate those things before the issues are even complained of or get to us, and that comes through better ordinances. Mayor.
Yeah, so first of all, I want to second what Paxton has said about, rational people can usually sit down and solve these problems. And I think from a city standpoint, most smart cities are going to want to minimize the expense and have an adverse decision with respect to either ombudsman or the courts. But so we do try to work things out. But the question I kind of have is in terms of the idea of a statewide appeal authority in these decisions. That's not a problem that I've actually seen. And I can understand why there might be or concern in the development community about going in front of a board of adjustment where people are not necessarily trained to make decisions based upon the legal framework that they should be using, especially in that procedural status where it's an appeal, right? But with respect to municipalities that have a land use hearing officer and who's law trained usually, it's like an administrative law judge effectively, is there a problem here? I mean, I'm not aware that we have a case backlog. Maybe that's a problem in other cities. I would be concerned, I think, that the state would probably develop a bigger backlog and it might be slower and more cumbersome than a hearing officer that's in an individual city. And the other concern I have that as local official is that a lot of the decisions that the land use hearing officer is making relate to local ordinances, and there's more familiarity because of they deal with those ordinances on a more regular basis than a statewide authority that wouldn't necessarily know those ordinances. So I'm just wondering, like, what problem are we trying to solve here, if there is one, with respect to a statewide appeal authority? And I'm willing to listen to that, and I'm willing to try to reform our process in any way that we can to make it better.
My name is Brandon Bell. I currently work as the countywide planner for Cache County, and I've worked for small cities prior to that. One of the things that I do is I'm tasked with assisting cities with land use issues and helping them understand land use law things and work on other projects related to that. One of the things that I notice is that I'm very appreciative of the Ombudsman's office. I've spoken with them a number of times in the past and previous responsibilities. And when you listen to their caseload, they are very clearly slammed. One of the things I feel like could actually assist in proper approvals is helping cities understand land use law and have access to legal counsel up front. A lot of these smaller towns and cities don't feel like they can afford full-time attorneys, but sometimes they don't need a full-time attorney, but they need better advice up front, and they don't feel like, there are instances I've become aware of where they're not necessarily getting good legal counsel, but the fact that legal counsel isn't coming up front has major cost implications and potential land use implications. So I don't know practically what the takeaway is from that, but I know it's actually sort of a logjam in some of the issues, is that cities either are trying to enforce something that they can't legally enforce, or they're afraid to enforce something that they can. And that comes back to a lack of land expertise or access to legal land use expertise up front in the process.
Yes. This question here, and then we've got one up front here.
Yeah, sorry, I didn't know if you wanted to have time to react to that comment. I can wait if you'd like.
I think that's a great comment. Just looking through the group here, there's a group called UMAA, Municipal Attorneys Association, that has been in existence for years. I remember when there were just 30 of us sitting in a room. Not every city has a city attorney. Many of the city attorneys are what they call outside counsel, outhouse counsel. Jody Burnett used to call them. And some of the city attorneys practice family law 95% of the time, and government law 5% of the time. And so yes, there's a great big hole there, and I think it's something that we've talked about as a municipal attorneys group, but have never acted upon. And really, it happens informally a lot. I can't tell you the number of calls I would get every week on issues from different smaller jurisdictions. Not minding at all to answer those issues, but there is a gap there. There really, truly is a gap. The gap is often filled by the Ombudsman's office. It is often filled by the League of Cities and Towns, calls to the League of Cities and Towns. You've got Todd from the League that gives legal advice, but there is often no knowledge on the part of these small towns, cities, and towns as to where to go to get solid legal advice on an issue that may cost them thousands of dollars if they don't address it correctly. Any question?
Curious to hear what Rob has to say.
I just wanted to respond to Mayor Silvestrini. I don't know what sort of backlog there is, but I can tell you from my perspective, we don't feel like we have a fighting chance to fight anything with standards so low as rationally related, reasonably related to furthering the purposes of LUDMA, rational basis review. We lose that all the time. It's sunk cost. It's a sunk cost for us all the time. So from the developer's perspective, and I think I speak for most of the developers in here, we are the ones that don't hold the keys. The cities hold the keys to everything, and we're at a severe disadvantage. We incur enormous cost, and most of it comes from waiting. I think the biggest win we've had in 5 years in LUDMA was to add consequential damages to a city who goes against an ombudsman opinion that took you 6 months to get, and that's only if it's knowingly. And that phrase knowingly was put in during the hearing up at the Hill, like the day they passed, or it got out of committee. And proving knowingly is even more impossible because it's just such a high standard to get past. So we have all these ways where we talk about dispute resolution, but really when anything's a legislative decision, we are at the complete mercy of the government. And we don't have any teeth. There are no teeth anywhere in this code, in the state, that says when you get led down the primrose path for 9 months and you have 800 grand into it and made promises, we all take that risk for hundreds of thousands of dollars of environmental reports, due diligence, site plans, engineering, studies. It's all the risk is on the developer. And then on the same side, we're called greedy, or we're ruining the state. We don't create a need for housing. That's like saying a hospital creates sick people. They just feed the need, right? And yes, we want to make money, but so do you, because you work and you have a paycheck, right? We're no different. But for some reason, it feels like in housing, we're socialist, that we want to control what it looks like, how much it is, what size it is, where it goes. But we don't tell Chevy how many doors to put on, or if there should be cruise control, or how many you can sell. We are not a free market for housing in Utah. We are not. And so we're trying to control costs, but we are incurring so much cost just waiting. And there is nothing we can do because the cities hold all of the keys. And we're sitting here begging, and we're trying to talk about dispute resolutions. There is no dispute because we can never win. The rational basis is so low. So I just want there to be a consideration for the risk that developers take, the money that we spend to create housing that we all live in, that you all live in, that we are not the bad guys, but we're looking for a way to move ahead. And it seems like on the PRC and the Land Use Task Force, a lot of complaints saying you guys keep pushing us and giving us deadlines. Well, everyone in the private sector has deadlines. And so we're looking for something to give some teeth when our property rights, we feel like, are secondary to what a city wants for their city.
Thank you. I'm speechless. Rob, thank you. You raised some excellent points. Every single year we kind of up the ante a little bit, but I want to ask these guys, put the question to you. Knowingly, that's how you get damages, right? If you go through the ombudsman process and you've knowingly and intentionally violated the law, and you refuse to change even after going through that process, then you get, they changed it about 2 years ago to indicate that you could get damages as a result of that. But just thoughts from the two of you. How many, you've served as appeals officers, how many knowingly situations, intentional situations do you get with local jurisdictions versus just negligent?
You want to take that first?
Sure. You know, I've served on the planning commission in my city for a number of years. I was the land use appeal hearing officer for a number of years, represented a lot of developers and builders over the years. And with one exception, I don't think I've ever encountered a situation where a city knowingly violates. It'd be so hard to prove where a city knowingly violates your property rights. Most of the time, it's either out of ignorance or just simply not having the guidance that they need to make the right decision. There's no question we've seen a lot of decisions that are wrong, and that's why we have the Ombudsman's office and we have legal recourse. Not always do you win, but I don't think I've ever seen a city intentionally, in bad faith, knowingly make the wrong decision out of spite or some other motive.
Yeah, I agree. I'm not saying that it couldn't happen, but I've never experienced it. I am aware of one city council meeting where one city council member once told an applicant that they didn't care what the advisory opinion said, they were still going to vote against it. They did say that in the public meeting. It came up for a vote, and that council member did not vote against it. They did what they should have done.
So we deal with the new board of directors as city attorneys every 4 years. They rotate. Actually, it's every 2 years you've got new members of the board. Every 2 years you've got new members of the board. That's what we deal with as cities. And some of them are new, some of them have been there forever. Those that have been there forever seem to understand a lot better the situations you're talking about, Rob. But 3 new council members can change the entire look of a city. They come in with the concept that I can change the world, I can stop growth, I can do this. Over time, that changes. But that's probably one of the biggest issues that we have to deal with as cities. Would you agree? That it's just lack of knowledge on the part of the cities. And to your point, up in Cache County, it's no different across the state. Without any type of legal guidance, they often make poor decisions, and it costs you money because it takes time. And the question, I guess, has always been, when you go to add penalties, whether or not taxpayers ought to pay for the incompetence of elected officials, and not intentional incompetence of elected officials, but negligent incompetence of elected officials. And so far, the answer has been no, we can't do that. We've got to educate. That's the better way to go, is to educate rather than to use a hammer. As far as the standard goes, yeah, rational basis for legislative, reasonably debatable for legislative, used to be rational basis until one particular case. But, and then even the administrative standard, Paxton? More, pretty much one judge described it as more than a mere scintilla, but less than a preponderance of the evidence. So figure that one out. So you're right. I see Rob smiling. It is really tough to win a case in the courts. That's why I don't think an appeal authority generally would work. I think we're out of time, and I thank you for being part of the panel and for raising the issues. So thank you very much.